Islam. Peace and grand rising to the sovereign, original, indigenous, natural divine heirs. Today is July the 25th, the day after the full moon, 1442 on the ancient moon calendar and 1441 on the ancient sun calendar, 2021 on the ancient Greco-Roman calendar, because again, we were Rome as well. So we have to own all of our various sovereign statuses and identities. We want to first acknowledge everyone who participated in this fast. It's not over yet. We will be, most of us will be breaking our fast at midnight tonight, or some will be breaking it at sundown. We want to just send out all types of wonderful, amazing, positive energy with regard to the fast. As usual, the ancestors have just opened up this entire weekend in terms of information. When we clear our systems, clear our temples, it removes resistance to electrical flows in our system, because we know we're electrical beings, as well as conscious beings and spiritual beings, metaphysical beings, natural beings. And when we fast, we actually allow the ancestors to bring clarity to the things that we say and do. Yes, Empress Tisa, you mentioned it in the chat, major download. Yes, we got several of them this weekend, and it's just been amazing. So again, over the next few weeks and months, we'll be implementing all that was given to us. And we're looking forward to even the next fasting period as well. So with that being said, we also wanted to fast, and I want to put this on the public record. My fast was also dedicated to the Moors who are being tested right now, those who are in the POW camp, the Moors who may not be in the POW camp, but you're dealing with declaring your sovereign status about foreclosures and your heirs being, someone attempting to take the heirs, etc. All tests. This fast was in support of everything that is being done right now, everything that has to do with our nation, and that's why we fast as a nation. It's so that the ancestors will continue to honor our sincere energy and send us the remedy that we need in our minds. It comes from within. So, we have been talking about, there is a lot going on in our nation. We're not oblivious to that, because some have been saying that we're really focused, and they may feel that we're not giving enough acknowledgement to the Moors that are being tested. We absolutely are, but we're doing that in reality, not just on paper and not just by words. We're actually fasting for our brothers and sisters so that we can get clarity and remedy as well. And so that we can send them some positive energy and some strength so that they can continue to stand on their square while they're demonstrating. That includes Rise of the Moors, our brother Jamal. That includes any Moors that are being tested. If you're being tested right now, this fast is definitely for you. We're fasting for you, and we're unified in the spirit. So we want to put that on the public record and make that clear, that we're not just about words. We're going to actually put it in action and fast so that when we turn down the poison food, we know the ancestors are going to continue to give us remedies. We know that. We're energetic beings, and energy flows through a non-resistant temple a lot more. And when non-resistance comes in many forms, it comes through programming, deprogramming of colonization. It also comes through saying no to the plate so that our bodies and our temples can receive the electrical, impulses and things that we need in order to think clearly, because we can think a lot more clearly when we're not poisoned, okay? And then the electricity can go through where the neurotransmitters and the synapse in our brain and all of that works more clearly and cleanly, plus our bodies heal themselves more. And with all of that going for us, and then we concentrate and put our focus on the empire. Seek ye first the empire, and all these things will be added unto you. It's going to come to us repeatedly. Our brothers and sisters that we're standing, holding space for them in terms of the fasting. And then fasting in unity. The fact that so many of us were fasting, that's unity. And it's going to continue. So with that being said, we do want to, with all that's going on, because, there's a lot going on in our nation. Moors are being tested where fiat is concerned. They're being tested where these old systems that are falling away are concerned. We do want to stay focused on governing the vast estate so that we can continue to put out there information that helps us to get the remedy that we need. So we need to, I encourage all Moors, if you have not received Moorish Sovereign Delarium, put your email in the chat, and someone will write your email down. If someone could scribe the emails that are placed in the chat, if anyone needs Delarium, so that we can get the Delarium to you by email, okay? Because you're encouraged to use the Delarium. Thank you, Empress, for that. We're also going to encourage all Moors to begin using the Delarium where supporting these calls are concerned. We are requesting 300 Moorish Sovereign Delarium by email, or you can mail it to us, whichever you prefer, once you print your Delarium off, okay? And again, we can print Delarium, as much Delarium as we want and need, but it's the sharing of the energy that makes the difference in our demonstrations and all that we do. We're also encouraging consular court actions and liens and the use of Delarium there as well. I will say this, commercial space on our land and merchant opportunities on our land, we have created that. We created that. And let me tell you how. A lot of the buildings, sometimes the corporate, and it's not the corporate, it's the subject at this point, they will say, we're opening everything back up. But when they open everything back up, a lot more of the buildings are emptier than they were previously. So it may look like things are back to normal, and it may look like colonization is that's being rolled back and rolled back and rolled back even further as we stand. And so, merchant activity and all of that is coming to a point where it's making room is being made for us by that perspective, okay? And that's something that we're doing by liens and court actions, and we'll be able to go in and do what we need to do on our land. So let's be patient. Yes, Justice Jezreel, they have to keep up appearances. They have to keep that up, and that's okay. They can keep up appearances all they want to, but we can really see. And some of the hybrids have even been doing videos where they say, they're saying everything is open back up, but look at these buildings. They're all empty. Room is being made so that the Moors can fully participate in our sovereign status and apart from the court status. We have some things coming up that we're going to be sharing with you as well in coming calls about how to do that, about how we're all going to do it. And it's going to be a national demonstration that we do. But we have to come out of that system first, out of capitalism. Capitalism is a system that is quote-unquote governed by black ink and capital letters. We are red ink and all lowercase letters, and we're going to show some more about that today. Start mailing out Delarium. Use it. You know, send a copy of the Constitution with your diallarium so that you let them, everyone who's commanding anything, know that you know, especially with regard to services, goods and services, that you're not the corpse that needed a service. You're the heirs. And according to the Constitution, you're using lawful tender to get the services that you need. That's doable. We can do that. We just need to put that Constitution in place. And we have copies of the Constitution that will be under the videos. They're under the last couple of videos that we've done as well, where we did a Constitution. So we want to also acknowledge the Perseid meteor shower. I saw a beautiful meteor shower last night. It was just beautiful. That in connection with the full moon and Venus, all of that is all in our favor. It's all in our favor. So we're going to continue using everything, all of the resources, because all of the energies are a resource as well. Now, today we want to put more emphasis on nobility. You might want to sign out and sign back in if you're having an issue with that. We want to put some emphasis, some more emphasis, and this is something we've needed to talk about for a while, where putting things in red and all lowercase letters are concerned. We're going to show you some things that we've heard about it and things like that, but we had to do our own digging and find out for ourselves. So all rise and stand. This is a sovereign, living, ancient, Article 3, Moorish American Al-Moroccan Council Court action. I am sovereign, living justice, Pauline Denise Ritchie, in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. We are the original indigenous, sovereign, ancient, Al-Moroccan, Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith and credit, our trust, our allegiance, and our energy are hereby vested in ourselves, for we are the people who are the original indigenous, natural divine, de jure Moorish National Republic, federal government, and other governments, other sovereign de jure Moorish governments. We hereby exercise all sovereign rights at this time and at all times and at all points in time, non protunct. So we've been saying about black ink and capital letters being a capitalism system that has been used to enslave and to kidnap, as it were, and to take the Moors and put them in POW camps and things like that. The capitalism system in black ink and capital letters is universally trademarked by and for the dead in commerce, i.e. the corporations, the corpses. Color and styling of letters according to international trademark laws is what we're going to talk about today, because this is where a lot of that has come from, and we didn't, we still did not know that this is where it comes from. We are the law and we are the government. Let's talk about this. Okay. So I in my research I went to a website. I just Googled, universal trademark laws or something like that. I think it was universal trademarks or patent office. I Googled something. Something of that nature, and I came across a website just to start my study, and just so that you're aware, when we're starting our study or we want to know something about anything, if we have a question about anything, we can Google something and just start there and see what comes up and look at it and say, okay, let me go a little further in the rabbit hole, down the rabbit hole, so that I can see some things. And the answer is, it's the law that they will give you what you need, exactly what you're looking for. So I came across a website. Let me go to this website here on the screen, and I'll show you what came up. This website came up. It's called moorishe.law. Okay, so that was like the first thing that popped up. So I just started looking around, and you know, when we're in that mindset of seek and ye shall find, ask and it shall be given, knock and the door will open, the ancestors put the information right there. So this is the first thing that came up. It was some, you know, random website, and I want to call your attention to this part right here. So it says here, too often people looking to brand a new product or service change the name closely connected to what they do. But if you call your website a writer's blog when it's just that, a writer's blog. Now, look how they wrote that. If you call your website a writer's blog and they put capital letters here, when it's just that, a writer's blog in lowercase letters, you'll never be able to prevent third parties from using the same names for their own writer's blog. So-called generic terms simply cannot be protected by law. Let's take a look and see what they're saying. Because when they talk about generic terms being protected by law, they're talking about black law. They're talking about corporate law, because this is a corporate website. Let's prove that it's a corporate website. It's got capital letters right there. So this is a corporation. They're talking about industry practices, etc. And so I thought, well, let me look at what it is that they're saying they cannot take jurisdiction over. Because, see, whenever they're talking about protection of something, because those are scare tactics, those are terms to do fear-mongering, where, oh, you won't have protection if you do that. Well, anything that they're claiming they cannot protect means that they don't have jurisdiction over it. Okay? So I looked up the word generic, because they're saying here, so-called generic terms simply cannot be protected by law. We don't need their protection, okay? In fact, we want to be out from under anything that the corporates are claiming that they're, quote-unquote, protecting, because they protect for their own benefit and not for the benefit of the heirs and the living. So when I looked up the term generic, this is what came up on my document. Let's go back to that's the one. Okay. So this is what came up. On the screen, it says generic. Generic as an adjective means genus. The Latin is genus, race, or kind. And we know that the subjects are mankind. The corporates are corpses, dead corpses. So they're not even mankind, they're corpses. This says of, applied to, or referring to a kind, class, or group, inclusive or general, opposed to specific or special. Well, when they say inclusive or general, they're trying, when you use the word general, you still got the word gene as the etymological root of that word. So when you say gene, that whenever I see that, I always pay close attention. Here it says in biology of or characteristic of a genus. Let's pull that up a little closer. In biology. Now they didn't say according to animals, they said in biology of or characteristic of a genus. A genus. And then I looked a little further, and I saw generically as an adverb. It says with regard to genus, as an animal generically distinct from another. Okay, so if animals are distinct from another by genes, then when you say that something is generic, that means that that is distinct from others. It's the opposite of what we thought generic meant. We thought generic meant just any old. Generic means without a label, and that's actually true. Without a label, that's true, and without a name, that's generic. So then I said, okay, let me look up genus, okay. Genus, here on the screen. Genus, the Latin is genus, birth, origin, descent, race. And again, this dictionary was written by hybrids, so they're going to put their part of the story in there. They're going to put that in there. Yes, Empress Tisa, that's great. She put in the chat off-brand. Off-brand means it doesn't have a label. That's important when it comes to the heirs and corporations labeling everyone Negro, Black, colored, and African American. We want to be off-brand because we get to determine who we are. So here it says, in logic, a class of like objects or ideas, and of course they're going to say having several subordinate classes or species. That is correct. In other words, we're the logical class that has subordinate classes. Okay, and again, let's know what we're reading. Branding is for property. Yes, it is. That's why generic is important when you're talking about trademark and patent law. Okay, because that's what we're talking about today. Trademark and patent law. Here it says, number 3, in biology, a classification, and that's what class is, a classification of plants or animals with common distinguishing characteristics. A genus is the main subdivision of a family and includes one or more species. The genus name is capitalized and precedes the species name, which is not capitalized. E.g., Homo sapiens, the scientific name for man. Why is it that the dictionary is distinguishing between what's capitalized and what cannot and is not capitalized? We're getting right down to the main deal here. When you start talking about genetics, capitalized and uncapitalized mean something. And they must tell the truth when it comes to that. There's a reason why one is capitalized and one is not. The one that's capitalized, even here in this definition where they capitalized homo and did not capitalize sapiens, is because they need to take control of the word. Because again, this is a hypothecated dictionary. Even the Black laws from first and fourth, we honor those dictionaries because they are a starting place for our studies. But at the beginning and end of the day, the Moors will have to write the law in order for it to be what it should be, more specific to us. They have to try and make things so that it's not specific to the sovereign. But they get really close, so we'll use that. And again, when you're talking about genes and genetics, there is capitalized and not capitalized. And just for general purposes, summum genus. In logic, and remember, part of our spells that we cast on our consular court actions, summus de sanctum unum. Summus de sanctum unum means we are the Holy One. We is a generic term specific to the genes of the one who's saying we. summum genus, in logic, a genus which is the highest. So there again, you're seeing a convergence there of the word, of the language that we use, which is why our language is so important, and the definitions of them. Okay? So then it says they're going to flip this. Okay? First they told the truth. In logic, a genus which is the highest. And then they flipped it and put it to themselves and said that is which cannot become a species in a higher genus. So in their corporate world, they're the highest. In our natural living world, earth, and in the heavens and the earth, we are the highest. We cannot become any higher. Who's higher than God? Can God be any higher? And they certainly cannot be higher than the highest. Islam, that's it right there. So now we want to take this information that we just talked about, genus, generic, because generic is the actual original term that we're talking about, which has the root word or etymological root word of gene, G-E-N-E, like gene ISIS, Genesis, the beginning. That's what we're talking about. And now we're going to go to this website right here that's on the screen. So I'm going to put this website in the chat so that you all can look at it with us. This is the website. And if you're having any issues, just copy the website as you see it here. Okay? Because we got to talk about, there it is right there. And this is from the U.S. Patent and Trade Office, .gov. That's where this document that we're going to look at is from. So let me put the document on the screen. One moment. Okay, this is the document. This is U.S. trademark law. And notice they even put that in black ink and capital letters. So they know who they are. They know who they are. So rules of practice and federal statutes. Capital letters, black ink. Let's keep that in mind. So now, what I did when I went to this page is I went up to find some, I wanted to find some phrases, okay? So the first phrase that I put in was color. Color. Because we're talking about red ink, capital letters, etc. So I wanted to take each part of that and just look at it, specifically and look at it. So in looking at color, there were 43 instances of the word color in this document. So I just started looking at them, clicking on them, just to see what I could see. So on page 24, this is the page that we're on right now. Now again, keep in mind, think about the difference between black ink and capital letters, a name in black ink and capital letters versus the generic in red and all lowercase letters. Okay, let's keep that as our main focus that we're surrounding this study by. So here it says, it's talking about how to trademark things. This is under the chapter requirements for a trademark application, a TEAS application. Okay. So they list a few things there, and then they say what you have to do in order to trademark something that has color in it. It says, if the mark contains color, the drawing must show the mark in color. And then it says, if a mark is in standard characters, okay, we got to keep the characters in mind because characters has to do with uppercase and lowercase. Standard characters. Standard characters is uppercase and lowercase. Standard characters, a mark comprised only of characters in the office's standard character set, typed in the appropriate field of the P+ form. So in the office's standard character set, now, Morris, get your pens and pencils ready and your dictionaries ready because I'm going to be mentioning some things that we have to do some study on together so that we can further affirm or invalidate what we're talking about. Because we're not just here to affirm what the ancestors have shown us. We're also here so that if there's any questions about what we're saying, we look it up and we deal with it, okay? And then we integrate it into our processes. So now, they have some things here with regard to characters. Standard characters, they tell you in here what standard characters are. If the mark is not in standard characters, a description of the mark. If the mark includes non-English wording, an English translation of that wording. So they want you to put it, if it's written in something that's not English with a capital E, non-hyphen, that's a minus sign that indicates the debtor status. We know all words are math too. That's called gematria, so let's keep looking that up. If the mark includes non-English wording, then they want you to put it in an English translation. So in this document, I'm just telling you, they want you to continue to put yourself under their jurisdiction because they can't deal with you if you're not doing what they say in this document. You're outside of their jurisdiction. Just know, too, and we'll prove it, that the U.S. Trade and Patent Office is not an office like you go in and there's a secretary, et cetera, et cetera. It is an actual court. It's a court. It is a court, and everything that comes from it is a court action under corporate codes and statutes. So they're saying an English translation of that wording. If the mark contains non-hyphen Latin characters, a transliteration of those characters. When they say non-hyphen Latin, they put a capital L and they have the word Latin in black ink. They want not a translation, but a transliteration of those characters. Do the study on the difference between a translation and a transliteration of those characters. And when they talk about English, they say wording. When they talk about Latin, they're talking about characters. It's a difference. There's a difference. And that is why we use Moorish Latin, i.e. or ancient English. Okay? So here at number 17, this is important. If the mark includes an individual's name, we're not individuals, we know we don't have names, or portrait, either a statement that identifies the living individual whose name, see that's the trick bag right there. Someone who's living does not have a name. We have appellation. The living individual whose name or likeness the mark comprises and written consent of the individual, or a statement that the name or portrait does not identify a living individual. So again, this is what they want you to do in the event that you were going under their jurisdiction. So all of this is designed, again, to put us under their jurisdiction. So we have to be really careful when it comes to how things are written. how we write things on paper. Okay? So now, number 17, this one, we need to look at that carefully because it speaks about a living individual. We are the heirs, the sovereign heirs. We're not individuals. And if any time that you are doing something like this, you would change the spelling. Based on what they're saying here, you would change the spelling of the word that they're using here. If you want to be a living individual, you would spell individual differently. You would spell it individual. Individual. And the reason you put an L on the end is because the root word of individual is divide. IN, we know, we can look up what that means. Yes, in the chat. So let's continue looking at this trademark law because we need to show that this U.S. Patent and Trademark Office, everything that they're doing it by court action and using black ink. They need you to put things in black first before you do anything else. They need black first. Then you can put everything else however else you want to put it. Okay? So let's go a little further in the document and look at some other things. This is now, this right here, types of drawings and format for drawings, etc. So if you're, submitting something, which we don't do, we don't submit to anyone. We don't even use the word submit. But here they're telling you who they are in their quote-unquote statute. Standard character drawing. Applicants who seek to register words, and we know registration it has everything to do with the fake crown instead of the natural living being. It says applicants who seek to register words, letters, numbers, or any combination thereof without claim to any particular font, style, size, or color. So they're telling you, not only do you have to, you need to know about font size, but you need to know about font style rather. The style, the size, and the color matters. You must submit a standard character drawing that shows the mark in black on a white background first. That's what they want you to do first, is agree to be black first. Then they'll say, if it's in color, then you can submit it in color after that, but we need it in black first. And then it says here, the application includes a statement that the mark is in standard characters, and when they say mark, they're talking about words, names, etc. It says in standard characters, and no claim is made to any particular font style, size, or color. So again, they keep putting emphasis on font style, size, and color. Special drawing. Right here, it says the drawing should show the mark in black on a white background unless the mark includes color. However, they then come back and say marks that include color. If the mark includes color, the drawing must show the mark in color and the applicant must name the color. Well, you have to assign a name to the color. And what do we know about names? But they first want it in black. They want it in black first, then you can show it in color. And then you give the color a name. There's a reason why they say you must name the color. So when we're looking at, this is a contract with a court, a corporate court. And this all goes back to the names in black ink and capital letters. They're telling you throughout this that they own that. Now, I want to point something out here. All numerals, right here, number 4, just above that, all numerals in the mark are depicted in Roman or Arabic numbers. Did everyone know? Are we all aware of what Roman or Arabic numbers are, numerals are? All numerals in the mark are depicted in Roman or Arabic. Did we know that we've been looking and using Roman letters and Arabic numerals the whole time? That A, B, C, D, E, F, G, that's Roman. Those are Roman letters. And when we put them in all lowercase letters, that makes us the original Rome, the indigenous Rome, not the fake. And yes, we did some things in history when you look back at what we did. We did some things. Okay, but we're the original Rome. We're the original Vatican. The Vatican is actually Timbuktu. Our teachers have told us that. And that's why it has all of our stuff, miles and miles and miles of our writings at the Vatican. And wait till you see those in red. And that is where those who wrote the Biblioteliothek got the idea of, well, everything that the Savior says has to be in red. They got that from the Vatican. Because they have to tell the truth. So, marks that include color. If the mark includes color, the drawing must show the mark in color, and the applicant must name the color, describe where the colors appear on the mark, and submit a claim that the color is a feature of the mark. Now, again, submit a claim, that is jurisdictional. So then I said, okay, they want you to submit, first of all. They want you to submit. Then they want the submission to be in a claim. Well, we don't submit to anybody. Who's higher than God? No one. So who would we be submitting to? No one. We speak by affidavit. So then I said, well, let me just, we use the word claim all the time. We use it all the time. Claim this, claim that, claim the other. So I said, I'm going to look up the word claim. And just for general purposes, and we had, of course, we looked it up before, and we've been using it. Again, that's why we spell it differently on our documents. We spell it K-L-A-I-M or C-L-A-I-M-E, okay? And there's a reason why we do that. Let's show why we do that. Why do we spell claim differently on our document? We spell it differently on our document because, just one moment, let me put the document on the screen. Okay. So I looked up claim. This is the meaning of claim that the hybrids have done in their dictionary. Claim as a verb transitive. And I put note, dictionaries not authored by Moors are not as precise as we intend, as our intention. Therefore, we change the spelling of words to ancient English so that the words state exactly what we intend for them to state. And this is why we change the spelling so that it's more precise. Because when you start looking in these dictionaries, it's going to give you terms that really kind of, but let's look at it. Claim. It says here to call, to cry out. Claim. The Latin is clamere, to cry out, to call, to cry out. Here it says, the first definition says to call for, to ask or seek, to obtain by virtue of authority, right, or supposed right. To ask. If you're asking or seeking, who are you asking? To obtain by supposed virtue of authority, right, or supposed right. To challenge as a right. So we can use the word But we have to know exactly what it means when we use it, and it has to be spelled properly. Properly being not like they spell it. Okay? And then, yes, Justice Yezreel said it in the chat, self-national expression invokes jurisdiction. Yes, it does. So it says to demand as due, as to claim a debt, to claim obedience or respect. Listen at how they're doing this now. To assert as fact. If you're asserting it as fact, instead of just saying this is the fact, that's fact. You just state the fact. To state. To maintain as he claims to speak good French. He can claim to speak good French all day, but does he really speak it? You have to actually live that. A frequent and valid use despite objection. To call for, to require, to deserve. Now, those are important terms, deserve. So sometimes I hear, Moore's talking about what they deserve. You got to know what the word deserve, when it's spelled like that in black ink, means. To deserve means do not give it to you. As this problem claims our attention. To proclaim is, when they say here, OBS means obsolete. In other words, this is an older use of the word. Obsolete, whenever you see obsolete, you probably should be using that instead. It means to proclaim, to call, or to name. And then they put here to ask. And again, we don't ask state courts for permission to be ourselves. In fact, the only time we're asking anything of state courts is, what is your name? Do you understand that you are hereby bound by the Constitution for the United States, 1789 and 1791? That is how we do the asking. Okay? We don't ask them for permission for anything. Now, if they're saying a claim is to ask, demand, insist, require, request, maintain, this is they're showing here why we changed the spelling. Because either you're asking or you're demanding. Either you're asking or you're requiring. Ask and require are not synonymous. The one who's asking is acting as king. That is correct. It depends on what you're asking. That's why they always talk about you have to ask the right questions. They don't ask the right questions. We have to ask the right questions. What is your name is the right question. Do you understand this, and this is the right question. That means, do you stand under the God who created you? We have to ask the right question. In the beginning was the Word, and the Word was with God, and the Word was God. The Word is the jurisdiction. If you ask the wrong questions, you're going to get the wrong answer, or an answer that you had not prepared for. So this is why we changed the meaning, because here this is a little bit deceptive. Ask, demand, insist, require, request, maintain. We're not requesting anything. Request, that means to re-question. Okay, so here, if you're using claim as a noun, well, let's look at the verb here. To have a claim, to assert a right, to cry out, to call. Now, verb as a noun, as opposed to here, up here, it's a verb transitive, a verb or a past participle. Okay. As a verb, as a noun, it is a demand for something rightfully or allegedly due. And this is why we changed the spelling, because if it's a right, it's not alleged. It is the truth. That's why we changed the spelling and don't spell it this way. We don't spell it C-L-A-I-M in black ink. We spell it a different way, and however you spell it differently is you're sovereign. You can spell it the way you want to spell it. You can put an E on the end. You can start it with a K. You can put two L's in there, however you do it, as long as it's in red and all lowercase letters. because these definitions are not specific. They're meant to be a little bit cloudy because it's still written in corporate English or common English. A demand for something rightfully or allegedly due. Well, when we spell it the way we spell, it is rightfully due. And then it says, number 2, a right to demand. Well, we know we have a right to demand. A title to any debt. They put that first for a reason, because if you put it in black, that's what you're claiming. Privilege or any or other thing in possession of another, as the prince had a claim to the throne. The thing claimed or demanded. Number 4, a statement of something as a fact. It's the language that they use tells you that we need to be more precise. A statement of something as a fact is not a fact. It's a statement of something as a fact. It's being asserted as a fact. It may not be a fact, it's asserted, it's a claim. Whereas we state fact, we state law. A loud cry or a loud call. And again, a claim is calling something out, and then there's a response that's going to come. However, when we assert our claim, again, when we, yes, Justice Giramore, that's another way to state what we're saying. We're all saying the same thing here. Noble Drew Ali says the Moors should learn to speak a second language, and that language should be Spanish. Yes, he said that. I would love to see some documents that he, where he would, or anything where he was speaking Spanish. Because I would love to see how he did that. Because I haven't seen any. And if anyone has seen any documents with him saying that, please let me know and let us know so we can publish it so the Moors can see where all of that came from too. We know, we honor our prophet. We know he said all the right things, and we love and appreciate everything that he did, period. So now I looked up the word claim, and here it is down here. Look at the synonyms. Pretension, right, title, assertion, a statement. Well, we know what pretension means. And pretension and right are not the same thing. Right and title are the same thing, but pretension and assertion could be more precise. They need to be made more precise because it's not a pretension or an assertion. It's a right and a title for us when we spell it the way we want to spell it. Yes, all lowercase script asserts non-English writing. You're absolutely correct there, Nobility, in the chat. You're absolutely correct. We don't want to speak English with a capital E and black ink. That's common English. We're not common, we're the nobility. And we're certainly not corpses. Corporate English is what they teach in corporate schools. And we have some who don't think that red, that black ink and capital letters, they don't think anything's wrong with it, but they're teaching you stuff. Was the school a corporation at the time that they taught you this? Was the school that you learned that in a corporation? Yes, it was. It was a corporation, so they were teaching you corporate precepts, concepts rather, concepts. Corporations are not going to teach you how to be sovereign. They're not ever going to do that. They're going to teach you how to be a corpse. That's why instead of making pencils in all other colors and letting us just do everything in red or yellow or blue or green, they said everybody write in black. A number 2 lead pencil, black. Corporate, period. So now let's keep going with this trademark situation, because they are the ones that are saying if you want it to be in anything other than black, then you're submitting a claim to them. That's what they're saying in this in these documents here. Okay, so look there on the screen now. Yes, Justice Frank, under occupation schools. And here's the thing, anything that they taught in those schools, we need to be questioning and looking at it and saying, we know that's not right. From the math to the science to the spelling and all of that, it's not right. It's not for the sovereign. Okay? So now, on the screen, they're saying, you know, that you fill out an application for all of this stuff, but when it comes to changing the color from black, you must submit a claim that the color is a feature of the mark. And I know I can hear some of the Moors out there. I can hear what you're thinking. The mark of the beast. Yes. Yes. We'll just keep doing the research. Don't take my word for it. Do your research. And prove. Prove. So they're also talking about registering and all of that to obtain a trademark. You know, they're putting it under corporate jurisdiction. And then they want you to submit a claim to a state court. Everything that we've been writing has been Roman letters and Arabic numerals. Anytime you go and read any document that's in Arabic, when it shows numbers, it's going to show the same numbers we've been using. Okay, so I like, you know, all of that they put there is showing us exactly who they are. So now I wanted to look also at, we'll go now to page, let's see. Yeah, when they talk about Latin letters, they're talking about Latin with capital L, okay? We mentioned that previously. Now, let's go to page 39, right here. And again, do your study on anything that you see here. The link is in the chat to the document. Do your study, because even as you all study, you're going to see some things in these documents that, you know, that we didn't bring out today. Okay? Yes, in the chat, 14 samples are given using lowercase letters. Yes. So let's look at part D here on this page. Okay. So again, the drawing must meet these requirements, etc. Depict the mark in black ink. Now, why do they keep saying black ink? Why don't they say depict the mark in any color you want to depict it in? Put it in any color. Or in color if color is claimed as a feature of the mark. Know that capital letters are not letters, they're marks. Capital letters are marks. They're not letters. They're hieroglyphs. They're glyphs. They're pictures, marks. And again, like we showed in the beginning, everything that you send them, you have to put it in black first, then you put it in color. Now, you can look further at these at this document just so that you can read some of the things that we're skipping through. Okay. Now, standard character, I think we went over this one already. So let's go further here. All right. Now, because we want to get to the part about the United States Corporation Company and how it is that the United States Corporation Company has been claiming everything in black ink and capital letters. They would not have been able to write this if we had said, okay, we want all laws written in red. Then they would have said, okay, we can't touch that because it's not under our jurisdiction. And that's why everyone has signed their sovereign name change or appellation change documents in red. So when we look here, it says the office will grant a date of receipt. Well, if they're granting, that means they're doing court action to an international application that is filed through T's in accordance with subsection 7.4a or typed on the official paper form issued by the International Bureau. They want you to fill out their forms and they want you to do it in black so that you're under, again, any form. See, this is the issue with the forms. All forms out there, no matter who issues the form, I don't care if it's child support, I don't care if it's child services, I don't care if it's welfare, I don't care if it's Social Security, VA, a mortuary, anywhere. All of their forms are trademarked. All of them are trademarked by the black ink and capital letters that they're using. They're trademarked by that. When you look at quote-unquote government forms, they have a form number at the bottom or in the upper right corner or whatever. That form number means that that form went through this court and is under the jurisdiction of this court. This court, which is the U.S. Patent and Trade Office court, is under the United States Corporation Company. That's why they have a separate section for them. And yes, Justice Seabay in the chat, mostly made up by attorneys. All of them are made up by attorneys who need everyone who fills those forms out to be under their jurisdiction, and we are not under their jurisdiction. We're not. Because, see, if you fill out of any of their forms, then you consented to be under their jurisdiction. Those black forms, under their jurisdiction. If it has a form number and that form number is entered in black, even if the form is red, because some of their forms, they put them in red, but it still has name, address, zip code, they're still putting you under their jurisdiction if you use those forms. And this is why. Yes, Justice Yangerel, note, he put in the chat, note that the document title, U.S. Trademark Law, is in all caps and black ink. It's all dead fiction. Yes. They're telling you here that when you have a form that you are sending and submitting, yes. So now here, at number, I want to look at this right here. A reproduction, let's start here. A reproduction of a mark is the same as the mark in the basic application and or registration, and that meets the requirements of subsection 2.52 of this title. So what they're saying is, when you do a mark, a reproduction of the mark is the same as the mark in the basic application. That means that if you put it in the copy machine, it's the same as the original. If the mark in the basic application, so if you put your just like when you copy a birth certificate, if you copy a birth certificate, the birth certificate is still under their jurisdiction. Still. Just one moment. Let's get that taken care of. It's still under their jurisdiction. Okay. One moment. Just one moment. Okay. Let me make sure that I just one moment. There it is. Okay. I think everybody made it in here. So now, if the mark let me get through here real quick. Go back to the chat. I want to make sure that I get everything in the chat. Okay. So now, if the mark in the basic application or registration is depicted in black and white and includes a color claim, see, you put it in black first, and then you have to claim a color. That's how this is done, according to them, because they're keeping you in a black status, and we're not black. Okay, we don't do black. Okay, but here, right here, if the mark in the basic application and or registration is depicted in black and white, and the basic application or registration does not include a color claim, the reproduction of the mark in the international application must be black and white. If the mark in the basic application or registration is depicted in black and white and includes a color claim, the international application must include both a black and white reproduction of the mark and a color reproduction of the mark. They're telling you there, you got to have some black in there because they need you to be black, period. They need you to be black, and we are not black. That is what all of this is about. This is why we keep talking about black ink and capital letters. Okay? Because you're putting your, and this is international law, by the way. So when they're claiming international law, supposed international law, it's corporate. It doesn't supersede us. It's international where corpses are concerned, where the dead are concerned. This is proof that everything in black ink and capital letters belongs to this court, fake corporate court right here. That's proof because they need you to do that before you can claim any color. Before you can claim something in red or whatever colors others use or whatever. So they have a specific place here, a color claim as set out in subsection 7.12, if appropriate. And you already know they're not going to tell you that much in that claim, but let's go look at it. Claim of color. If color is claimed as a feature of the mark in the basic application and registration, the international application must include a statement that color is claimed as a feature of the mark and set forth the same name of the color claimed in the basic application and or registration. So you got to assign it a name, and we know we don't have names. If color is not claimed as a feature of the mark in the basic application or registration, color may not be claimed as a feature of the mark in the international application. So now they're talking here about remedies. Now, we know this is remedy for them, not remedy for us. Remedies, infringement, and innocent infringers. Any person, and there it is, person, the word person, who shall, without the consent of the registrant, and when they talk about registrant, they're not even talking about owners or heirs or anything. They're saying, again, that's another jurisdictional term that puts whoever fills out their form, they put you under that status of registrant instead of international or universal heirs. Okay? So it says, any person who shall, without the consent of the registrant, use in commerce any reproduction, counterfeit copy, or colorable imitation of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services, on or in connection with which such use is likely to cause confusion or to cause mistake or to deceive. Haven't they done that with black ink and capital letters? It's deceit. It's semantic deceit. They're the only ones who are persons. So this is even for them. Reproduce, counterfeit, copy, or colorably imitate a registered mark, and apply such reproduction, counterfeit, copy, or colorable imitation to labels, signs, prints, package, wrappers, etc., intended to be used in commerce. And again, in commerce, we're not persons, we're not registrants, and all are subject to the Moors. In connection with which such use is likely to cause confusion or to cause mistake or to deceive, shall be liable in a civil action by the registrant for the remedies hereinafter provided. Again, this is where our Article 3 courts come in at. Our Article 3 courts come in where any claims by any U.S. Patent and Trade Office in black ink and capital letters, we must rebut it as the sovereign Article 3 court in red and all lowercase letters. We must. Because they continue to claim the black ink and capital letters. They continue to claim it. That's how you know it's under their jurisdiction. They're telling you here out of this corporate court that it's under their jurisdiction and that color matters and that style matters. The writing style matters. So here at let's see, 28, let's go back to 128. Let's go back to the page 128. Right here. 128, 3, part 2. If the mark in the basic application is depicted in black and white and includes a color claim, the international application must include both a black and white reproduction. If the mark in the basic application or registration is depicted in color, the reproduction of the mark in the international application must be in color. So that's telling you also that there is an international jurisdiction, which for us is universal jurisdiction, and then there's also another jurisdiction underneath that, to where separate quote-unquote application is to be made. So we're going to show here where in these things and where they're talking about remedy, what we can do as Moors in order to further, and it's the same thing we've been doing, except it's going to be a little more detailed in terms of what we do to remedy that black ink and capital letters piece. We must remedy that. So let's look here at remedies for that. Now, we know that what they have done is when our sovereign mother spoke on the day that we were born and we crossed the sovereign stargate, when they spoke, for example, my mother, she said she spoke the sovereign-born appellation of Pauline Denise Ritchie as my sovereign-born appellation. And then there was a harbor master at the end of the table doing business as a doctor who changed what she said and put it in corporate language. That is absolutely a misuse, an unlawful use in commerce of the original. It's an unlawful use of the original. She spoke it originally as a creditor. Our mothers never would have made us debtors at birth. And they couldn't make us debtors because jurisdiction, that even by consent of both parties, jurisdiction cannot be waived. That's the law. The law says jurisdiction cannot be waived even by consent of both parties. Even though our mothers said what they said it meaning this is the creditor, not a debtor. But because the Moors, we were not there waiting at the table to intercede and do read, living birth affidavits, we left it up to the corpses. So what did they do? Attempt to have us to claim to be corpses. Okay? So we already know that we're supposed to be doing all of that. We're supposed to rebut those fake documents with the real document. And I'll tell you that people have been talking about authenticating birth certificates. That thing can't be authenticated because it's fraud. You have to have the real one in order to do anything with the fake one. You must have the real sovereign living affidavit. Okay? So they have unlawfully in commerce used colorable imitation of our sovereign mark. Our sovereign mark is marks that we proclaim by bloodline and birthright. We know they claim black ink. They're telling you throughout this document, and you can read the document in detail when you have the opportunity to do so. So here, they're saying this is what happens. There's liability here. In a civil action, there's liability. Well, we know that their courts are not going to give us remedy because their courts are going to do nothing more than what they've been doing, which is attempt to have us to, they're using semantic deceit to attempt to have us claim to be a court. So when Moors would go into those fake courts and say, I am, Pauline Denise Ritchie or whatever or like Tajiri Bay, either one, they would take that, and because we didn't put qualifiers behind it, such as in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio redes. We didn't put those qualifiers behind it in the past in our sleep, or even when we first woke up as Moors. So they would take it and automatically put it in black ink and capital letters and keep proceeding on their course. So it's up to us by court action, by consular court, Article 3 consular court action, for us to put it out there on the public record that we are not any name in black ink and capital letters. And if you go out onto YouTube at Light Tajiri Bay and you go to, there's a court action that was done on January the 1st where the Article 3 court, the highest court in the land, said that Pauline Denise Ritchie in black ink and capital letters is a fraud, and that Pauline Denise Ritchie in capitis diminutio is the real living heir. Then that was placed on the public record. We're not any name in black ink and capital letters. That was tested in February. I tested it myself in February and proved it to be true. They have copyright to all black ink and capital letters. And even if it's one capital letter and all lowercase letters after that, they still have copyright to that. They're telling you here, as used in this paragraph, any term, the term any person includes the United States Corporation Company and all agencies and instrumentalities thereof. That includes fiat. Fiat is an instrumentality of the United States Corporation Company. Okay? That means that the use of it puts you under their jurisdiction. And when we know better, we got to do better. That's what delarium is for. We got to come out of her. Okay? Now, just one moment. Let me remove any, there. We'll put that out of there so that we're not distracted. Because see, when we're talking about things like this, we see in the chat that there is some attempt to distract from what we're talking about here. They don't need you to know this. They don't want you to know this. They don't want you to know. They want you to be distracted so that you don't know that what they were doing is fraud. So yes, Empress, a hit dog will holler. That is the truth. That is honest. That is the truth for sure. So now, let's see. They're talking about remedy. There is remedy in a court, but it has to be the right court. It has to be the right court. Their courts are not going to give you remedy because guess what? A court issued that. A court issued that black name. A court issued it, but it was a corporate court that issued that black name. So the sovereign court must rebut it properly. Copyright and trademark law says that when you do things generically, that they can't copyright it. That means they can't take jurisdiction over all lowercase letters. They can't. They cannot. It's written that they can't. So now, we're talking about remedy here. When an infringer or violator is engaged solely in the business of printing the mark or violating matter for others and establishes that he or she was an innocent infringer or innocent violator, the owner, now they're not talking about registrants and all of that now, they switched over and started saying owners. The owner of the right infringed or person bringing the action under section 1125A of this title shall be entitled as against the infringer or violator only to an injunction against future printing. That does not apply to the heirs. Where the heirs are concerned, there is no statute of limitations on fraud when it comes to our courts. There's no statute of limitations on fraud when it comes to our courts. Yes, there it is in the chat. All of that with regard to those, you know, seeking to not let this information go forth. Now, all 501c3s are registered under the United States Patent and Trade Office in black ink and capital letters. All 501c3s in black ink and capital letters. And they may say, I never applied to that office, but this office has the patent on that. They're telling you here when they talk about font style, font size, and font color. And then they keep referring to black this and black that, and everything has to be black first, and then you can put your color on it. So when you have time, look through all of this because I wanted to ensure that we know where to look and where they've been doing all of the things that they've been doing. There's another section here that also refers to remedy. This is so important right here, this whole section right here. This is page 232 of this document. Now, this part right here, and this is still under internal application originating from the United States. This is still under page 128, subpart B that we showed you earlier. All of this is still under that. Now, this subsection 36, destruction of infringed articles, is why we're saying what we're saying about come out of that capitalism system, because it's on a path to destruction of all things in black ink and capital letters. We're proving it right here. Just read what's on the screen. It's going to show you where we need to come out of that. Because it's saying anyone, in any action arising under this chapter, in which a violation of any right of the registrant of a mark registered in the Patent and Trademark Office. So all they're saying is anything that's happening with us. And here's the thing: when Moors claim to be United States citizens, United States Corporation Company citizens, we're actually infringing on the dead. We're infringing on the dead. Black ink, capital letter, that is a violation under their 1125A of this title, or a willful violation under 1125C. Once that shall have been established, okay, any action has to be established first. In order for anyone to execute the law must first be established. In order for anyone to execute the law must first be established. Well, if we're standing right there and we're the law, then the law is already established, but we have to know it. We have to know it. And we don't establish our law in black ink and capital letters. We do it in red and all lowercase letters for this very reason. This is a 274-page document. Look through it so that you can see that they have the patent on that black thing. Yes, the hybrid, Empress Shade in the chat, hybrids are running from it themselves. That's why the hybrid acknowledged, yes, they are trying to write things in blue and in white. Those are the two colors that they choose the most, the blue and the white, for the hybrids who are needing to escape black ink and capital letters. And then in some cases they will choose purple or something like that, but I don't even think purple needs to be what they need to be pulling, what they need to be using. I'm pretty sure it's blue because we said it's blue. That's number one. But number two, even according to the law, subjects are expressed with one capital letter, and this is in the U.S. Writing Style Manual. So look that up in the older Writing Style Manual. Any law library should have an older Writing Style Manual. It'll be easier to find it if you go to any of the quote-unquote colleges or universities to like the old, to their libraries, or you can go to a Masonic lodge and look at their library, and they should have an old etymology book. They should have old dictionaries, old law dictionaries. They should have books that translate from Latin and Hebrew, etc., that you can use. Okay? But you must be in your proper person to do any of that even. So they're again here talking about, now they're saying if any action arising under this chapter shall be established, the court may order that all labels, signs, prints, packages, wrappers, receptacles, and advertisements in the possession of the defendant bearing the registered mark, or in the case of a violation of Section 1125A of this title, or willful violation under Section 1125C of this title, the word, term, name, symbol, device, combination thereof, designation, description, or representation that is subject to the violation, and this is why no one represents the Moors, or any reproduction, counterfeit copy, or colorable imitation thereof, and all plates, mold, matrices. This word right here is a derivative of the word matrix. Something else to think about and study when you have a moment. And other means of making the same shall be delivered up and destroyed. Do you see what they're saying there, Moors? That, yes, justice now in the chat, that's real good right there. Red and blue mixing makes purple, Islam. That's something to think about when you think about us and the subjects. That will make the subject, when we put them in subject status, and then we give them some delegation in subject status, then that's where they start claiming royalty, etc., as opposed to our sovereign nobility. That's where that royalty comes from, is amalgamation. And we don't need to be really amalgamating because they don't have any. And amalgamation is a commercial term, by the way. It's a commercial term. And so we don't need to be giving them any delegation. They're subjects. They take commands, not delegation of authority. It's a command. It's not us giving them any of our sovereignty at all. It is, you're commanded to do this, you're commanded to do that by affidavit. Because as you can see here, anyone using those names in black ink and capital letters shall be delivered up and destroyed. And here they're listing all kinds of property and all of that, terms, names, symbols, devices, combinations, designations, descriptions, representations, etc. Reproductions, counterfeits, copies, colorable imitations shall be delivered up and destroyed. And then it goes on to speak about the court. The party seeking an order under this section for destruction of articles seized under Section 1161B of this title shall give 10 days notice to the United States Attorney for the judicial court, the judicial district, in which such order is sought, unless good cause is shown for lesser notice, and such United States Attorney may, if such destruction may affect evidence of an offense against the United States, they're telling you about remedy here, against the United States. Seek a hearing on such destruction or participation in any hearing otherwise to be held with respect to such destruction. Okay, we don't need to appeal to them for anything. Our courts need to be speaking with regard to any property or anything that has been seized under colorable imitation of our sovereign status. Okay? Any property that's been seized under colorable, willful violation, then we need to be bringing it to our sovereign court, issue our ruling, and then send that ruling by notification to this state court. You can send it to the USPTO, the United States Patent and Trade Office, but know how to do that. It's done in red ink, all lowercase letters, and when you're talking to them, that means you've done a lien and a court action on this United States Corporation Company Patent and Trade Office. So liens and court actions are definitely in order by all Moors of this particular office. Because see, even when you think about the Moors who've been taken and they're incarcerated, this is why and how. This is why and how. This is how that happened. So we actually went through the exercises of proving that this is how and why that happens. Yes, all that's being put in the chat, yes, absolutely. Except what the hybrids put in there. So why would they use the term delivered up? Delivered up first and then destroyed. Why do you think they use that term? They use that term because that means that something's been seized. Something has been seized. And before you can destroy it, you have to seize it first. They're talking, yes, they're talking about property. We're not property. Anything in black ink and capital letters is property. If you're using even one capital letter, it's property because that's called non-Latin with a capital L. Black ink, black. They're very, very crafty, okay, with the way they put this stuff out here. But we know how to read. So as remedy, the court action that I did on Pauline Denise Ritchie in black ink in capital letters and that fake social security number in black ink with the minus sign, that court action, I hereby deliver it verbally by proclamation to the U.S. Trademark and Patent Office as subject to the Moors. I deliver it hereby right now that it be. I'm delivering it up. And actually, I'm delivering it down because you can't get any higher than the God. Delivering it down for destruction. That means all debt is going to be destroyed. This is the written version of what we did in January. Yes, Justice Yezerel, ooh, that's brilliant. This document is the protocol for capitalism. Absolutely it is. So we need to be looking at this and saying, okay, let's clean this up and put it in red on government affidavit and speak and do a lien and a court action on that, this black office here. And look here, they're saying even further, the party seeking an order under this section for destruction of Article C, listen, all articles that we want destroyed is going to be paper because they only exist on paper. So what will be destroyed? Everything that they copyrighted in black ink and capital letters. That's only going to leave the creditor. It's only going to leave the creditor. Yes, Justice Empress Shade. Many people have experienced their corporate debts being wiped already on paper. Yes, absolutely. We all need to, but see again, the debt is, if they did that, the debt is theirs and they claimed it and then they got rid of it. We are able to say the debt was never ours. There was semantic deceit involved. Yes, Justice Timothy, he said this document can be placed in red ink. Yes, absolutely. Red ink in all lowercase letters and issued from the original indigenous United States Trademark and Patent Office or Patent Ministry. Because we're the original. Yes, absolutely. That can be done by any Moors, and any Moor who decapitalizes and decolonizes this document. Place it on the public record. Let us know about it so that we can publish it so the Moors can use it. And here, as you're doing these demonstrations with regard to that, you're putting all of these in subject status, okay? Moorish consular courts can adjudicate and should adjudicate. We're actually the only court that has the lawful authority to adjudicate where these matters are concerned, and then we can notify all of the fake lower courts. And when we raise the lower, because you have to do a court action on the court, the fake inferior court. When they only become subjects when we do court actions on them. Then we give them our court ruling, and then we say, okay, let your record reflect this properly. And then we tell them how to reflect it, what their records should say. We correct their records by putting them in subject status. Yes, absolutely, absolutely. And so, let's see, a couple of things. Yes, they did claim it by false means. Here, this is another important part. Subsection 37 of this document refers to 15 U.S.C. 1119. Power of court over registration. Notice they put the word court in all lowercase letters, but even still, that's just diluting to us, but we have to put it in red. Certification of decrees and orders. Decrees indicates that there is some authority that is higher, doesn't it? So, yes, in the chat, nobility, Noble Timothy, put the USC codes in all lowercase letters like you've done there. That is absolutely correct. Then decapitalize, put it in red ink, yes, and issue it as your sovereign Article 3 ancient court, consular court order. Fraud and civil liability. Well, let's look at number 37 first. In any action involving a registered mark, the court may determine the right to registration, order the cancellation of registrations in whole or in part, restore canceled registrations, and otherwise rectify the register with respect to the registrations of any party to the action. Decrees and orders shall be certified by the court to the director, who shall make appropriate entry upon the records of the Patent and Trademark Office and shall be controlled thereby. When they're talking about court here, we're talking about our court. We are talking about our court. Our court shall control everything. And when we say destroy the debtor, we mean destroy the debtor. We mean destroy the debtor. Get rid of the debtor. We don't want debtors on our land. The subjects are subject to the creditor. And when they get in subject status, their debt does go away. They don't own anything. They're not, they're not the owners of anything. They don't have any claim to anything. Their only claim is that they are subject to the Moors. And whatever we say is what goes. Here, 38, fraud and civil liability. Any person, and we're not persons, any person who shall procure registration in the Patent and Trademark Office of a mark by a false or fraudulent declaration or representation, fake courts represent the Moors by this right here. That's fraud. That's fraud. And here it says oral or in writing or by any false means. Now, Moors, that means that we cannot speak, citizens speak. Even though our documents and affidavits are in red, if we go to those fake courts and don't turn it into Article 3 right away and know how to do that, which is by our sovereign proclamation, all rise and stand. This is a sovereign, ancient, Al-Moroccan, Moorish American Article 3 consular court action. I am sovereign, living justice, etc. That takes the fraud out of you being there. Yes, some may try to talk over it and all of that stuff. Then if they're trying to talk over, because see, here's the thing. Yes, Justice Amos, they cannot wait. The subjects have been waiting for us to get them out of their debt. They've been waiting for that. These fake courts, if they see, we're putting it on the public record that we know who's who. So if they keep doing and they're not going to keep doing it, we're putting it on the record to stop doing it. So therefore, it stops for those who consent and agree that it stops. If Moors consent to still use black ink, there's nothing we can do for them. If they still think that they're United States corporation company citizens under the Constitution or under anything, then there's nothing we can say or do because they're sovereign too. Their word must be honored. That's why it's important for each one of us to stand on our square. My square is my square. Your square is your square. And then we assist one another and tag team on the chessboard. That's how we win. So they've been doing everything, and now they're mentioning civil liability. Wherever you see the word civil, just replace it with sovereign liability. Just replace it. Civil rights are for citizens. Civil rights are for citizens. Thus the term civil liter mortuus. That means a citizen who's dead or a sovereign who's claiming to be a citizen. This is how we govern our vast estate. We are the law and we are the government. And no, the 501c3s did not want this to get out to us. They didn't want us to know this. Because now we're doing court actions on them. We have to. We can't let them keep putting us under that. So all of the Moors who are in the churches, you're going to need to do a court action on the corporation that's covering the original non-commercial, not commercial Christian church. Because again, we're not mad at Christians and Christianity. We started that too. Everything starts and originates with the Moors. But the corporate commercial covering of the dead needs to come off of that, and they need to take all those fake, fraudulent, any representation of the living, they need to take all representations out. That includes those fake Bibles, the ones that are in all black. I'm just saying, you want to talk about a book burning? The ones in black, where even when the Savior, quote unquote, speaks, they're speaking in black ink and capital letters. Those books need to be burned. Oh, I did say that. Yes, I said that. I said that on the public record. I said burn it because it's fraud. And the ancestors are validating and affirming what I just said. They just sent a little chill. Burn it. And then also, we need to rewrite. And some of you who are on social media, you will see on my Facebook page where I will take scriptures from the Biblioteliothèque and put them in red and all lowercase letters in ancient English and give them its proper, put it in its proper status and jurisdiction. I do that often because even the Biblioteliothèque is based on ancient writings by our ancestors. Yes. So now, there's a really important concept in here that we definitely need to look at. Because this has everything to do with our vast estate. The court action that I did in January was abandonment of mark of the black ink in capital letters. And it really, the mark never was mine. It never was mine. It was actually banning it. Banning the use of it, abandonment. The root word is B-A-N, ban. This is more remedy right here, but we have to change this up so that it states what it should state. Abandonment of mark. A mark shall be deemed to be abandoned if either of the following occurs. And note that when they say the word deemed, they're talking about by court action. A court has to deem something abandoned. A court must do that, a sovereign court. Only the Moors can do that. It says, when its use has been discontinued with intent not to resume such use. Intent is the key. Intention is the key. It must be discontinued. We cannot use the black ink in capital letters. Intent not to resume may be inferred from circumstances. In other words, some have used, for example, when some Moors have gotten pulled over and they used the driver's license or they went back to a contract, but they went back based on demonstrating at their level of overspending. So we shouldn't beat ourselves up about that, Moors. Don't beat yourselves up about it. Now, I can't do it because I've already done court actions and everything, so I can't do it. But intent not to resume may be inferred from circumstances. In other words, if your energy is pure and you're not trying to get a benefit from a court, but you did it until you could get to the study part or the knowing within you, then the ancestors will honor that as well. For example, when we first woke up, we were doing documents like the ones you see on moorisheamericanconsulate.org that are in black ink and capital letters. Some of those documents we wrote. We wrote them based on our study at the time, which was years ago, like 3 years ago, 3.5 years, 4 years ago, almost, okay? And when we put those documents forth, the ancestors honored them because our intention was pure. The documents had gone through the Moors, and the Moors started putting the documents out. Yes, our ancestors honored the energy, but when we know better, we have to do better, or else then we're talking about now willful violation on our part. Okay? So again, here, non-use for 3 consecutive years shall be prima facie evidence of abandonment. We love it. We absolutely love it. However, this is their version of that, but everything that we do, even if you're a Moor and you just learned today that everything should be in red ink and red ink and lowercase letters, you can just put it in red ink and lowercase letters, nunc pro tunc. Nunc pro tunc. That means now for then. So then that just takes away all of that. That takes away any time constraint. Infershade. So, so here, number 2, when any course of conduct of the owner includes acts of omission as well as commission, causes the mark to become the generic name for the goods or services on or in connection with which it is used, or otherwise to lose its significance as a mark. What is that saying? What is that saying, Morris? It's saying that an act of commission is a court action. We have caused our sovereign-born appellation to be generic. It's not a name, it's an appellation, and this is where knowing our language comes in at. But what this is saying is when something is generic, it loses its significance to them as a mark of the beast. To them. Generic, anything that's generic, whenever you look up words that are generic, they're all going to be in all lowercase letters. But then when you talk about things that are specific in corporate language, it's going to have a capital letter. That's what their noun, pronoun teaching in those inferior corporate schools was all about. They took the generic or the gene or genus of our all lowercase letters and they gave it a label, a title that it was not supposed to have. It gave it a corporate meaning. We want to be generic. Like we said at the beginning of this call, we want to be generic. Generic is all lowercase letters. Coloring is going to be, we're not colored people, because colored does mean black. So everything is flipped. We got to put it on its right, when it's in its rightful place. So whenever a mark becomes generic, it loses its significance as a mark. And that is, again, why the Al-Moroccan-American exchange is so important in terms of taking back the corporations. That were those that were doing business as corporations, we have taken back all the resources and left the courts there. The resources of the companies belong to the heirs. And when we put it in red ink and we put it out on the public record, and the Moors began investing in their own inheritance, don't you wonder why we can put that out there and no one be on the news saying, oh, they're infringing on our trademark. We're going to do a court. You know, nobody's door is being kicked in over that because they don't have jurisdiction over it. They don't have jurisdiction over that. We are without the United States Corporation Company in black ink and capital letters, and just as Jezreel said it, they can't use that which is without their jurisdiction. We are without their jurisdiction. Okay? And looking at this document, they're going to refer to color and colorable this and colorable that, because it matters in trademark law and patent law. And the word patent, when you separate the word patent, Okay, can you hear me? Hopefully you can hear me. Now, Islam, can you hear me? That happens when we start talking about the things that we talk about. Okay, so yes, of course, when we strike a nerve, even, you know, it happens. And I'm glad that, yes, I see that some trolls did get in. We'll put them out. As soon as they say something, we're gonna put them out. So now, what we were going to say is, with regard to this whole document, the entire document should be put in red in all lowercase letters so that we issue it as our own sovereign patent office. Except where it says putting things in black, we say put it in red first. So wherever you see the word black, just put the word red. So now, when I left off. Thank you, Empress Ali. When you talk about separating the word patent separated is patent. P-A-Y-T-E-N-T-E or P-A-I-T-E-N-T-E. Patent or patent. Okay. So with patent or patent, pay means exactly what it says, that there's some exchange involved. And tent is T-E-N-T. A tent, when you do the definition of it in the dictionary, tent is an extension of something. So like if you have an oxygen tent, there is the original oxygen machine, and a tent just extends that. Okay, that's what tent is. So, just a moment. So, patent is that exactly what it says it is. Okay, so when you get a moment, go ahead and look this document up. Just one moment. Okay. When you get a moment, look the document up and look through it so that you can you will have a bunch of codes that are in the document that we can put in red in all lowercase letters and use those codes. We are the original IRS in red and all lowercase letters. Everyone owes taxes to the Moors, and let's not, there's no mistake about that. We're the original U.S. Trade and Patent Office in red and all lowercase letters. We're all of that, which is why we have the authority to issue Article 3 law to the subordinates and subjects and have them have their records reflect properly. So now, one last thing I want to say before we bring this call to a close about this whole issue of color and colorability and all of that. Let me go down to just a few things here that we need to look at. Page 247, right here. When we hear more talking about being the holder in due course, they're always referring to this right here, holder of an international registration. Okay. When we want to proclaim a sovereign, proclamation and make it the law with regard to claiming of anything, including the vast estate, we would spell holder a different way. You can put two L's in there, H-O-L-L-D-E-R. And then you can put, because we are the holders of all universal records. Okay, so as opposed to the word registration, you can say records, or you can use the word registration but put an E on the end or change the spelling of it so that it means what we mean it to be. Okay, just one second. Let me, just a second. Okay. So when you hear people talking, referring to universal commercial codes and or actually not universal commercial codes, but UCCs, and they reference the holder in due course, and they're talking about all of that. We are the original holders of all, so you can use that term but spell it differently, okay, so that it puts you in your proper status. Additionally, let's see, on page, page 217, I think we went over that one, because that is another remedy for all debt. Okay, yes, this is it right here. Opposition. And it's saying any person, and we know we're not person, so when we rewrite this, we will write it, and we can spell person a different way. Okay? So if I were to rewrite this document, I would say any sovereign who believes, actually any sovereign who knows that he or she was previously damaged by the registration of a mark upon the sovereign register, because we have the original register. It's in red and all lowercase letters. And if there's been any damage by fraudulently counterfeiting our sovereign status and using a fake black ink in capital letters, and it says here, which would be likely to cause dilution by blurring or dilution by tarnishment. And I would just say to cause injury by misrepresentation or representation, because no one represents the Moors. May, and they're saying here upon payment of a prescribed fee, but of course we pay in Moorish sovereign denarii. And it's just an exchange for us. We don't have to pay them anything, especially not with fiat. We can't push fiat anymore. File an opposition in the Patent and Trademark Office stating the grounds, therefore, within 30 days after the publication under this subsection of this title of the mark sought to be registered. Okay, so we're not seeking any registration from them, but you can look through these codes right here. This is a code for us to look at over the next few days and weeks and months, and rewrite it in red and all lowercase letters and issue it from your sovereign United States Patent and Trade Office Ministry Court. Okay? Issue it from your court. Okay? Cancellation. A petition to cancel a registration of a mark stating the grounds relied upon may, upon payment of the prescribed fee. See, they got to put that fiat in there. Just know that they got to put the fiat in there. And the reason they put it in there is because the reason they put it in, can you all see what's on the screen? Is it subsection 14? Is that showing on the screen? Okay. And so the reason why they want, at least, they don't care, it can be $1 in fiat. They don't care. They just want jurisdiction. Again, fiat is jurisdiction to them, not us. So that's why they always put it in there. Okay. And they're saying if this is, you know, there's some remedy here in terms of, but we have to know how to execute the remedy using, and we can use these codes and statutes, but we got to put the codes and statutes in red and all lowercase letters. Okay. So as I move forward, and this is just something that I'm going to do. If we look right here, it's going to say, it talks about generic registration. A registered mark shall not be deemed to be generic, to be the generic name of goods or services solely because such mark is also used as a name or to identify a unique product or service. They're telling you right here that if you're seeking remedy, you can't have a generic anything. It has to be something that's not gene specific. Gene specific, that's what generic is. Generic is always noted in all lowercase letters. They're saying that you can't get the remedy if it's generic. Okay? If it's generic, they don't have jurisdiction over that. And that's in all lowercase letters. Specific marks contain specific lettering and specific names of colors. And here they're even talking about the primary significance of the registered mark to the relevant public. What do you think they're saying? They're saying here that when you talk about generic names of goods and services, etc., they're not speaking about everyone. They're only talking about certain ones. Certain ones. Okay? They're not even talking about everyone. They're talking about anyone who agrees and consents to be under their status, their jurisdiction. So let's take a further look as well here at this document. They do a test to make sure that it's whether it's generic or not, because if it's deemed to be generic, then they have no control over it, none whatsoever. Okay, and generic again is all lowercase letters and not specific. Generic, generic, and we did the definition of that. Are there any questions, comments, etc. about this? Any questions or comments? Let's see. I want to make sure I don't forget anything. One last page. This is going to prove that they're a court. Page 69 of this document. So if you want to go ahead and flip to page 69, you'll see here. Let's take a look at page 69. Discovery, discovery deposition within the United States. The deposition of a natural person, and again, we're not persons, shall be taken in the federal judicial district. Well, they're trying to say it has to go up higher. All that means is our court is where any of this stuff should take place that we're going to correct. If we wanted as the natural beings to correct anything, this is where it should be done, in Article 3, Sovereign Moorish American Al-Moroccan Consular Court. Because they're saying here, the deposition of a natural person shall be taken in the federal judicial district where the person resides or is regularly employed or at any place on which the parties agree in writing. The responsibility rests wholly with the party taking the discovery to secure the attendance of a proposed deponent other than a party or anyone who at any time set for the taking of the deposition is an officer, director, or managing agent of a party or a person designated under their federal rules of civil procedure. So whenever we republish federal rules of civil procedure, they're no longer federal rules of civil procedure. They're a federal laws of sovereign procedure. So all we do is just put them in red in all lowercase letters and use them. Okay? So if there's, I'm going to go ahead and unmute the call so that those who, if there are any comments or questions about what we've discussed here, it can be, let me just make sure we get rid of any that I can see here. Okay, we're going to go ahead and unmute the call, and if you have any questions or comments about
Islam?
She might have gotten dropped in.
Two fucking hours, and she had absolutely nothing to say. What the hell is wrong with you Negroes? Why do you listen to this bullshit? This is nothing but bullshit. Why aren't you out trying to spend your delirium?
Okay. Are there any other questions or comments from the heirs?
Islam? Cynthia Ann Bay here.
Yes, Islam.
On a July 24th writ by Anna von Reitz, she instructed her audience that they must write in blue ink. So we are not the only ones who have this conversation. Islam.
Really? Say that again, Empress. When was it? Because I'd love to see that.
On the I will send it to you. July 24th. Okay. She told her audience that they must write in blue ink, and then she also gave them instructions on how to talk to that system, and I swear it sounds so much like Grand Sheik's latest affidavit that he's, has gifted the world. So I will find that. I know where it is, and I will send that to you. Islam, yes. Grand Rising.
Islam. Yes. See, the color does matter, and now that we're standing, that's the only way they were able to come out of being black. And that's only those who consent to come out of being black. It was, she said that it was Anna von Reitz. And for those who know who that is, you can Google her. She's out there. She's a hybrid who has been holding lots of information with regard to, to some. Okay, in her corporate status, she looks like someone who's trying to hypothecate and pretend to be us. But as a subject, she's given a lot of information that we can actually clean the information up and use it, But again, everything that's in black ink, we have to clean it up and use it anyway, okay? Including the treaty that's in the Library of Congress, that fake corporate Library of Congress, we have to take all of that stuff and put it in red ink in all lowercase letters. Yes. A lot of the ones that are doing business as quote unquote sovereign citizens used to use a lot of that stuff. Yes, Islam in the chat. Yes, I see affirmation there. So with that being said, are there any other questions or comments?
Islam?
Yes, Islam.
Well, two things. Number one, I sent that video. Mark Christopher was talking a lot of stuff about that capitalism stuff, and on his little today's video, if people want to look it out, it's probably about 20-something minutes, and he was going in, and he always is telling them to write in blue as well, and the thumbprint, and he will say the what's it called, the stamp, and so forth. And he's always telling them to give your instructions. Tell them what you want them to do. When you come with something, he says pretty much a lot of the same stuff that we're saying. You know, he's saying the same stuff as well. And then I noticed on this page in 69 that you have up, how they had federal, only federal capitalized. And, of course, judicial district was in lowercase letters. So they were already showing that there's a difference.
Yes. Yes. Yes, absolutely. They make the difference in, they stipulate whether something should be in capital letters or all lowercase letters. And we just have to pay attention to what they're doing. Yes, Empress, that is absolutely correct. Are there any other questions or comments, etc.?
Islam.
Islam nobility.
Enrique Albe. I begin to study within language and indifference of language, and it seems like it's more intelligent property and patent than anything else. And the problem with that is able to encode the indifference, where certain people are able to understand the difference and not the difference. Mm-hmm. And since this is not an official language country, and this is always going to be a problem with the corporations to have the indifference, we first have to establish the indifference within the patents itself, as to go into internationals and to provide it over here as where it's only in federal. And the other part to that was I believe that the state court doesn't have an ethic committee. I believe the federal court does. And that's the biggest indifference of all.
An ethics committee?
When you have a bar association, you are facing ethic committees, where the fact is, just like a doctrine, a doctor mm-hmm. has an ethics. Where mm-hmm. the fact is, in most of state courts, they don't have ethics committees at all to represent the ethics, what the court actually does. And when you reach up to federal court, they have to have it.
Right, and we're actually the federal court.
Right.
We're you know, so we have to have that first, the ethics, and which we do, and honor. Ethics is a hypothecated version of the word honor. And then we can speak to those courts that you're referring to. We can speak to them as inferior courts. Yes, absolutely. You're right.
Because you have a branch of court that branch out into state and local, which doesn't mm-hmm. acknowledge ethics at all.
Well, they don't have to if they're dealing with citizens that are black, you know. And when I say black, you know, we're talking about letters, paper,
right? Because
they only exist on paper. Islam. Thank you for that, nobility.
You're welcome.
Islam. Thank you. Okay, we're going to go ahead and pause the call here, and then we will meet back again on Wednesday at noon Eastern time. And then on Thursday at 7 p.m. Eastern, and then again on Sunday at 6 p.m. Eastern. Thank you again to everyone who has sent in Delarium to support this call. Whew, we got the support we need, definitely. And we're grateful that we fasted in unity. And let us just end our fast with gratitude and unity as well. Thank you so much, and peace and grand rising to the end. Islam.
Peace and grand rising.
Islam.
Islam.
Right. Long live the empire.
Islam.
You ain't in the meeting. Like, you get off the screen.
Islam. 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 Grand Rising.
Islam.
Totally at that time.
Hello.